Health Services NHS Trust.
Yes, Mr.
Good morning, my lady, my lords. I appear on behalf of the appellant claimant, together with my learned friend, Mr. Jeremy Pendlebury. Appearing on behalf of the respondent defendants are my learned friends, Mr. Philip Havers, Mr. Bradley Martin, and Miss Ruth Kennedy. My lady, my lords, I don't propose, unless it would be of assistance to you, either to introduce the case and the facts of the case, or to go through, line by line, the appellate's case.
We would very much hope that you would not do that.
Thank you very much. I hoped you might say that.
Yes.
Both
parties' cases were, if we may say so, admirably short, clear, and helpful.
Thank
we
you.
wish that all counsel would take the same line.
Well,
what do you propose to do, Mr. Massey?
Sit down. My lady, what I thought I would do is try and encapsulate what we say is the law in this issue, and at the same time answer the points made by my learned friends in their respondent's case. And my lady, my lords, I start with making the concession that in the Court of Appeal I made probably 3 errors. Well, there may have been more, but there are 3 that I appreciated. The first was that I failed to prevent both the respondents and the Court of Appeal addressing the question of whether, in the circumstances of this case, it was fair, just and reasonable for there to be a duty of care. The second error I made was that I failed to prevent the Court of Appeal from eliding issues that related to duty with issues that relate to breach. And thirdly, I failed to prevent the Court of Appeal from analysing the issues from the perspective of an individual, namely the receptionist, rather than from the standpoint of the defendant, the trust. And my lady, my lords, our case, in summary, is that this is a conventional personal injury action. There are no novel principles that have to be applied to the facts. There are a variety of control mechanisms that apply to ensure that there is not a floodgate argument that can be raised against us, and that in those circumstances, given the findings of fact, this is a straightforward case in which there is a duty of care breached, which was followed by causation. May I start with the question of fair, just and reasonableness? My lady, my lords, knowing as I do that 3 of your number were in the case of Robinson, I think it would be ill-advised for me to suggest what you meant when you said certain things. All I'm going to do is to remind the court, if it needs reminding, of certain things that were said. I don't think I need to go to the authority to say that it was established that in straightforward cases which have no novel principles, it is unnecessary and indeed inappropriate to start with the principle of, well, is it fair, just and reasonable that there should be a duty of care? And that we find in the case itself, and if I may just take you to it very briefly, it's Robinson, page 402. And I take my lady, my lords, to page 409, paragraph 15, first 3 lines, in the Court of Appeal, Lady Justice Hallett considered that the Caparo test applies to all claims in the modern law of negligence. That perhaps is my mitigation for my failure in the Court of Appeal. But
I haven't got the dates in my head.
Robinson came out after.
I think so.
The Court of Appeal judgment came out before, but Robinson in the Supreme Court came out afterwards. Otherwise, my lady, I don't think I'd have dared to make the point. So, my lady, that was the proposition, and paragraph 21, the proposition that there is a Caparo test which applies to all claims in the modern law of negligence, that in consequence the court will only impose a duty of care where it considers it fair, just and reasonable to do so on the particular facts, is mistaken. And, my lords, my lady, I don't know that I have to go beyond that. The respondents, appreciating that that is the position, say 2 things. First of all, they say, well, the judge and the Court of Appeal recognised that this was a novel case on the facts. And then they say, well, whether or not they did recognise it, it is a novel case on the facts. And, my lady, if I can take the court to the blue bundle at page 53, paragraph 6. Of the respondent's case.
Thank you. That's lovely. Thank you.
It's 53 on the memory stick as well.
Thank you. The trial judge and the majority of the Court of Appeal recognised that there was a novel type of claim which raised an important issue about patient responsibility. It thus appears to be the case that the respondents are accepting the principles in Robinson, but are saying, well, this is a novel case. And because it's a novel case, one does consider questions of fair, just, and reasonableness. We do not accept that the court regarded this as a novel case. The 2 references that they rely upon are page 104, the trial judge, and page 80, the Court of Appeal. And at 104, paragraph 85, all the judge said there was that we seem to live in an age where there is a perception of increasing reluctance by individuals to take personal responsibility for their own actions. It is difficult, we submit, to suggest that that paragraph is a recognition that this is a novel type of claim. And at page 80, paragraph 57, Lord Justice Jackson said, as the judge said, there comes a point when people must accept responsibility for their own actions. The claimant was told to wait, he chose not to do so. Without informing anyone, he simply walked out of the hospital. Again, difficult to see that that was a recognition by the Court of Appeal that this was a novel claim. And indeed, if one turns to page 77, paragraph 43, it is evident that the court did not address the question of whether it was a novel claim or not, because, as they say, let me now turn to the authorities cited in the skeleton arguments and oral submissions. Both counsel take as their starting point Caparo. It's evident in our submission that the trial judge and the Court of Appeal simply took the view that one starts, as Lady Justice Hallett suggested, with the question, if there is to be a debate as to whether there is a duty of care, one starts with Caparo and whether it's fair, just and reasonable. So, my lady, my lords, we submit that in the context of this case, one must ask whether it is novel, whether there is anything novel about it at all. We submit that there isn't. There was a clear relationship between the claimant and the defendant. Indeed, there was a relationship the moment he walked into the hospital. Nobody could doubt that as soon as he walked into the hospital, there was an obligation as an occupier to the claimant. But at the point when he booked in and engaged with the receptionist, he was in a patient relationship with the hospital. And, my lady, my lords, to simply look for novel facts that don't impact upon principle is, we submit, not what the court was attempting to do in Robinson. So if we come back to Robinson, and we turn to page 412. Paragraph 27. The test is, it is normally only in a novel type of case, and this we submit as the important clause, where established principles do not provide an answer, that the courts need to go beyond those principles. Thus, it is not simply that there are novel facts, it's where the principles don't provide an answer. And over the page at 413, where the court was considering the judgment of Lord Justice Hobhouse, and he was referring to the Mark Rich case. In the indented section, if a plaintiff is attempting to establish some novel principle of liability, then the situation is different. Mark Rich should not be regarded as authority which has relevance to cases of personal injury, or as adding any requirements that an injured plaintiff do no more than bring his case within established principles. If the plaintiff is attempting to establish some novel principle of liability, then the situation would be different. Thus, my lady, if, for example, to use cases that have come before the courts recently, we were attempting to show that he had suffered upset, disturbance, concern, for example, that would be a novel suggestion. And we would have, in those circumstances, to look at whether the current principles applied. If we were attempting to suggest that the defendant was liable for economic loss alone, that would be a novel principle in the context of this case. But we're not. We're attempting to suggest that as a result of an act on the part of the trust, he suffered personal injury. There is nothing novel in those circumstances. And if it were not made clear by those two paragraphs, it is summarised at paragraph 29, page 413. The last sentence of that paragraph: all that is required is the application to particular circumstances of established principles governing liability for personal injuries. My lady, my lords, we say that this is therefore not a novel case, but in addition to that, we say that all of the necessary control mechanisms that one must have in a case of negligence are provided by established principles. There is no novelty about this case which requires an additional control mechanism. Thus, I've already mentioned, in the question of duty, there has to be a relationship. There is a relationship of occupier and visitor as soon as he walks through the door. There is a relationship of patient with the trust once he has booked in with the receptionist. And as Professor Goodchamp made clear in his article, there never was a suggestion by the respondents that in some sense he was not a patient. So there is a relationship. That relationship provides the first control mechanism, because of course, if he had simply walked into the hospital with his head injury, there would be no suggestion that there was a duty of care on the trust before he had booked himself in to be in any sense treated. Secondly, the existence of that relationship is not sufficient. There has to be foreseeability that if one acts in a way that is careless, it may result in harm. Well, the judge found in terms that there was foreseeability, but that is a control mechanism, and it is a hurdle we overcame at first instance. When one moves beyond duty and comes to breach, there is a further control mechanism. And I failed to persuade the Court of Appeal that this is a control mechanism that relates to breach and not duty. Because the control mechanism is that the staff only have to act reasonably. There was a tendency in the Court of Appeal to treat our submissions as if they were arguments for strict liability. You must give the correct information or you are liable. And that was never our case. Our case was, you must take reasonable steps to give the correct information. And what is reasonable will depend upon the circumstances. The circumstances will obviously be such matters as whether the hospital is a haven of tranquility, to quote Lord Justice Jackson, or whether it is particularly busy on that day, or what role the person who the claimant is associating with plays when giving him information or advice. But those are all matters that relate to breach. And indeed, the respondents' documents that they have produced showing how many people go to the accident and emergency department and when they go and what's a busy day and what isn't a busy day, insofar as they have any relevance at all, which we submit that they don't, go to questions of breach. Of course, when one assesses the actions of the receptionist, one doesn't do so in a vacuum. One asks what the surrounding circumstances were. But that's nothing to do with duty and whether there is a duty of care. It is all about whether the receptionist breached that duty of care. And then, of course, we have the third element of a tort of negligence. We have duty, we have breach, we've overcome those hurdles, we then have causation. And with respect to the respondents, they have also elided issues to do with causation with duty of care. Because what is the gravamen of their complaint, I ask rhetorically? It is it not, that the claimant walked out of hospital. He was a man, as they assert, of an adult, of full capacity, and he made his own decision to walk out of the hospital. Well, that's a causational issue, because once it is established that the defendant played, and I use this term because it comes from the authorities, once it is established that the defendant played an active part in the decision-making process, it becomes a causational issue. Thus, if the defendants, respondents, had been able to show that the claimant would have left the hospital whatever they had said, we would have failed. No causation. If the defendant respondent could have shown that we would have left the hospital at a time when nothing could have been done to have helped him, we would have lost. These are causational issues. Once it is established that the defendant has played an active part in the decision-making process, then the question arises, would there have been a different outcome as a matter of fact, factual causation? And we have to overcome that hurdle or that control mechanism. But even that isn't sufficient because, of course, we all know that factual causation is a necessary but not sufficient ingredient, and so therefore there has to be causation in law. And that's where issues of remoteness come into play. Proximity between the act of the defendant and the injury sustained. And perhaps it is that the defendants, because they say on a number of occasions, this was not a direct act on our part. We didn't directly cause injury. The injury came as a consequence of him leaving. Perhaps the defendants are there saying, well, there isn't sufficient proximity between their act, or it's too remote, is their act from the injury sustained. But we submit, no, these are established principles. Have we persuaded the court that as a matter of fact, the loss was a consequence on the information given? Yes, that was the decision taken by the judge. Is there any reason as a matter of law why the defendant should not be liable for that loss? Answer, no. It was foreseeable that not only would he leave, but that if he left, he would suffer harm. It was not too remote a consequence in the sense that there's no suggestion that there was some intervening act of a third party that broke any chain of causation. These are causational issues. They're nothing to do with the question of, is there a duty and what is the scope of that duty? Of course, considerations may apply as to scope of duty when one looks at the injury sustained. So if the injury sustained was, for example, financial loss, we would say, well, what's the scope of the duty? But we don't have to go there because this is a standard personal injury action. And so, my lady, the reason, and forgive me, but the reason I went through that was to show the control mechanisms, because it is a significant part of the respondent's case, as we understand it, and this is why all these statistics have been produced, to show that, well, hundreds of thousands of people who leave A&E are going to be bringing claims against the NHS. No, there are all these hurdles that have to be overcome. And that is not a point.
Are they control mechanisms or simply the principles of the law of negligence?
Well, they're both, aren't they? Because they are principles
They're
of the
not
law.
artificial control mechanisms.
No, they're not. But they operate to reduce the cohort of people who are going to have a claim. That's how they operate.
Really, it's a response. I think you're responding to the floodgates argument.
Yes, I hope I'm not just responding to the floodgates argument. The point I am trying to make is the ordinary rules of negligence produce hurdles, control mechanisms that the claimant must overcome, which means that when you get to the end of that process, there is a situation in which the claimant ought to be a claimant who is deserving of compensation.
In effect, are you saying that control mechanisms in this context is synonymous with the application of fundamental principles
Yes.
of negligence?
It is synonymous. One can call them the fundamental principles. What do they have? What practical effect do they have to reduce the cohort of people who are going to be able to make a claim into circumstances where there would be a legitimate expectation on the part of the public that there would be some recovery? We don't often, and it is not necessary for us to consider the legitimate expectation of the public. But for example, in the Kent case, the Court of Appeal did so. And one of the points that was made, well, what would ordinary members of the public think? And I ask the question rhetorically here, what would be thought by the ordinary member of the public that somebody was given incorrect information in circumstances where there was no excuse for it, as a result of which he suffered personal injury that was foreseeable, but you can't claim? The other problem, of course, with the introduction of statistics as part of the thought processes which one must adopt when looking at duty of care, is that statistics are statistics. Is it to be suggested, for example, that because A&E departments are busy on a Monday, there's a duty of care on a Tuesday, but not on a Monday? Well, obviously not. Or is it to be suggested that because the statistics show that it's busy on a Monday, one doesn't bother looking at whether the actual A&E department on this particular Monday was busy? Well, obviously not. The statistics argument, insofar as it goes, has no application to the ordinary principles of the tort of negligence.
Would it be fair? I appreciate it doesn't arise in this particular case, but would it be fair to say that the principle of contributory negligence would be another factor that could limit liability in this kind of situation?
Yes. My Lord, a point I was going to come to, because even when one gets beyond the question of whether there's liability, in order to reach a result that in the expectation of the public would be a legitimate result, you are entitled to consider matters of contributory negligence, yes. So, my lady, my lords, that I hope crystallises why we say it is not a novel case. And why we say that in the circumstances of this case, there is no reason to consider elements of whether it's fair, just and reasonable or anything else. And perhaps the position was put particularly well by the Court of Appeal in the Wiltshire case at page 457 of the bundle of documents. Halfway down the page, starting with the section "To My Mind,"
Whose mind are we talking about?
Lord Justice Mustard's.
Lord Justice Mustard.
Yes, this was not the
This is in the Court
House
of
of
Appeal.
Lords, this is the Court of Appeal case. But my lady, because of course my lady will remember that it went to the House of Lords on the question of, well, you've got a number of...
You've got all these possibilities and we
Exactly.
can't tell which, so
Exactly.
you lose.
But on this issue, Lord Justice Mustall was saying, to my mind, this notion of a duty tailored to the actor rather than to the act which he elects to perform has no place in the law of tort. Probably not a contentious consideration. But he goes on at the bottom of the page. To my mind, it would be a false step to subordinate the legitimate expectations of the patient that he will receive from each person concerned with his care a degree of skill appropriate to the task which he undertakes, to an understandable wish to minimise the psychological and financial pressures on hard-pressed young doctors. In other words, one does not subordinate the general principles of the law of negligence simply because in particular circumstances or with particular organisations there is going to be what might be regarded as something that is oppressive to them. And so it would be wrong, we submit, to subordinate the laws of negligence in this case to the particular circumstances of the National Health Service. Once one does that, is a factory going to be able to say, well, I'm very sorry that you sustained an injury, but we were incredibly busy? Is a private hospital going to be able to make those distinctions? Are we going to effectively say that the NHS should be a particular and solitary exception? So, my lady, we say the control mechanisms are there. We say they apply in these circumstances because it's not novel. And we say that it is inappropriate to consider the particular circumstances of the organisation when determining whether those rules should apply. But my lady, even if we were to suggest that there is some novelty to this case, then that does not mean that one jumps to the issue of ventilating whether it is fair, just and reasonable for there to be a duty, even if there are novel aspects of the case. Because we come back to Robinson at page 411 and paragraph 25. Where my Lord Reed was considering Caparo and made the point that where there is a novel question, one actually first looks at whether there should be an incremental approach. So in other words, is it novel? If not, standard principles. If it is novel, let's have a look at the incremental approach first. Does that provide us with an answer? If that doesn't provide us with an answer, then in those circumstances, we may go on to consider aspects of policy. Well, in this case, is there a way of looking at cases by analogy in order to give us the answer? We submit yes. We submit that the way in which Kent and Griffiths can be looked at is an example, where, of course, the Court of Appeal held that one way of looking at that case, not the only way, but one way of looking at that case, is that the ambulance controller gave incorrect information to the patient, as a consequence of which the patient sustained injury. And in those circumstances, there was no suggestion that there should not be a finding of liability. Now, the ambulance controller is presumably a paramedic, not a simple receptionist. But in each case we look at, as we saw in Wiltshire, the role that was being performed and ask whether that role was being performed competently. And here we have a situation where there is a relationship between the patient and the ambulance service by virtue of the fact that the control has accepted the call. And at that point, it is asserted that incorrect information that leads to injury is sufficient to find liability. And not exactly the same facts as here, for obvious reasons. And no doubt the respondents will say, well, the difference between Kent is they stayed there waiting for the ambulance. Whereas in your case, you left. But that is a distinction without a difference. Imagine, for example, in Kent, if what they had been done, having been told, let's assume they had been told, as was in fact the case, it's going to be 40 minutes, it's going to be an hour before the ambulance arrives. And let's assume that was false information. The ambulance was 5 minutes away. But acting upon that false information, the patient tries to get the bus to hospital because the patient thinks it's going to be quicker. Is it to be suggested that in those circumstances, if he suffers injury, there's no liability? False information, having been given, caused him to take a particular action which led to a personal injury. So we submit that there are analogies. One can dream up a number of others. The GP receptionist who has an administrative job, who doesn't send a letter that she should send, and as a consequence, personal injury results. Is it to be suggested that that GP receptionist is not going to be liable in those circumstances, or rather, and more appropriately, the GP practice as a consequence of her being vicariously liable for her failings? And, my lady, my lords, I'm not going to go through a number of others, but one can see what I'm talking about. There is, therefore, if one is looking for an incremental approach, a clear way of saying there are circumstances which plainly give rise to a duty of care that are analogous to the situation that there was here. And it is only if you're against me on those first two propositions that I even have to go to the question of whether, in the circumstances of this case, it is fair, just, and reasonable for a duty of care to be imposed upon the respondent. So you must reject my proposition that this is not a novel case. You must reject my proposition that there is an incremental approach that provides the answer. And then we look at the Caparo question of is it fair, just, and reasonable. And then specifically, we go to look at the various arguments that are put forward by the respondents, floodgates, a defensive attitude, the difficulties that there may be in terms of evidence. And my lord, my ladies, the reason that we put into the bundle the article from Tafaris and Steele was because in that bundle they deal with those arguments, and probably rather better than I do. And so we invite the court to look at what they say. My lady, if one looks at page 493, they deal with defensive policing, And they say that its status in case law is weakened by the fact that although accepted in some cases involving public authorities, rejected by others. If one turns to page 500, they deal with the excessive litigation, a risk of speculative litigation in a way in which most individuals in private sector companies are not. And they say what the argument shows is the need for adequate control devices when assessing the negligence liability of the police in such circumstances. And of course, that's why I've been focusing on all of the control mechanisms that already exist as part of and synonymous with the rules of negligence, because the control mechanisms are already there. And they deal with the special status of the police at page 504. And here, I do pray in aid some particular facts, because as in Robinson, it was accepted that, generally speaking, another control mechanism that is used by the court is whether there has been a specific act or whether there has been an omission. It's rather easier to establish liability in circumstances where there has been a positive act, a commission, than it is when there has been an omission, particularly in circumstances where we're talking about simple bystanders. But in Robinson, the court accepted, of course, the proposition that where there is a special status that a defendant has, it may be somewhat easier to show that an omission provides liability. And we say that if you are looking at the question of whether it's fair, just and reasonable for there to be a duty of care here, the special status of the defendant as a hospital trust is of importance. Why? Because the respondents in their case emphasise over and over again that the claimant was a man of full capacity who chose to leave. Entirely his decision what he should do. Completely ignores the fact that the man was vulnerable in an alien environment without knowledge of the procedures of that trust or that hospital, in pain, and very possibly, though we cannot say, somebody who was unlikely to take considered and rational decisions. And that was evident to the receptionist. It was evident to the receptionist that he was a man in some extremis. Why? Because he actually said, "What happens if I collapse?" And he was told, "Well, if you collapse, then you'll be seen." The receptionist knew he had a head injury. Not a question of somebody turning up, looking for all the world as if there's nothing at all the matter with him. So there is a relationship here whereby we have a vulnerable person in an alien environment who doesn't know the practice and procedures, who is relating to a defendant trust with its organisation and its decision as to how it will set up its business. And in those circumstances, we submit, if ever it's going to be fair, just and reasonable to impose a liability, one imposes the liability because of that differential between the two sides. And I repeat, because it is important at this stage, that this is not a question of us asserting that the claimant succeeds whether he would have stayed or not. Our case was that the information he was provided with played an active part in his decision-making process, and the judge accepted that. So we submit that if we come to questions of fair, just, and reasonableness, then one has to look not simply, as the Court of Appeal did with respect to them, from the perspective of the trust and the NHS, but also from the perspective of the individual and what he might be expected, or the condition he might be expected to be in, and what he may take from what he is being told. The respondent's case is, well, he chose to leave, and the information given to him was given simply as a matter of courtesy. And we submit that is an untenable, an unsustainable argument. We submit that it is the legitimate expectation of anybody who goes into an A&E department that if they ask a question that is going to be important to their decision-making processes, that reasonable steps are taken to provide accurate information. Note, reasonable steps are taken to provide accurate information. So the protest from the defendants, and indeed from Lord Justice Sales in the Court of Appeal, well, they may give a piece of information, it may turn out that different circumstances apply. There may be, it may have said it's a 1 hour wait, and then there may be a traumatic incident. Well, they're only required to take reasonable steps. We're not saying there's a strict liability here. And the words of Lord Justice Sales again, well, this requires the measurement of precise words in certain situations. No, it doesn't. We're not talking about precise words. We're not talking about analysing words as a commercial lawyer may analyse a shipping treaty. We're actually asking, was what that individual did in the context of the office they held, namely receptionist, reasonable? And the judge, well, there was no explanation given at the trial for why the receptionist should give the information that she did. What was accepted is that she knew what she should have said, that it was her usual practice to say what she should have said, and the experts agreed that that is what she should have said. Namely, you will be seen by a triage nurse within 30 minutes. That is what she should have said. The defendant's case was she didn't say what the claimant alleged she'd said. They did not put forward a justification for what she said. So for the defendants, for the respondents in their case to submit that if there is a duty of care, there has been no breach, is, we submit, completely unsustainable in the circumstances of this case. The judge found that information that was given was inaccurate and there was no justification for the inaccuracy. And so, my lady, my lords, in the context of this case, was it fair, just and reasonable? I've dealt with that. Was there a breach of duty? I've dealt with that. And then the final argument put forward by the respondents goes back to the question of causation. And they say, well, he made his own decision. But that flies in the face of the reality of the situation. I repeat, they played an active part in his thought processes and his decision-making process. That was accepted by the judge. it was foreseeable that having been given that information, he would leave or might leave. It was foreseeable that if he left in those circumstances, he would sustain personal injury. Causation was thus established, and it assists the defendant not at all simply to say, well, we were not the direct cause of him leaving. So they argue the other side of the coin. They say, well, all right, but he not only did he leave, he left without telling anybody. And that is sufficient for there to be a causational argument against him. Well, he did leave without telling anybody, but they knew he had left, and there was no evidence before the court as to what would have happened in circumstances where he had said, well, I'm going home now. So the respondents did not adduce evidence that had they been told that, attempts would have been made to stop him. Indeed, quite the contrary. They were rhetorically asking the question, is it the responsibility of the hospital to stop a man leaving if that's what he chooses to do so? And so that doesn't take the defendants or the respondents anywhere at all. And it's in that context as well that we submit that if there was an argument that could be raised, it's an argument that is more usefully framed in contributory negligence. He took an irrational decision or an unreasonable decision in circumstances where so did the defendants breach their duty. My lord, my ladies, my lady, my lords, I hope that I've crystallised our case. I hope that I've dealt with the assertions put forward by the respondents. I stop at this point, subject to any observations or questions my lady, my lords have, and I stop for this reason. Essentially, our case is very, very simple. It is, we are within the standard principles of the tort of negligence, and the judge has made findings that in the circumstances of this case mean that we succeed. It doesn't help if I say that 15 times or in 12 different ways.
No, it doesn't.
Hasn't stopped some people from trying that.
I haven't. My lady, if there are any questions, if there's any other issues I can help about, of course I'd be delighted to do so.
Haven't got any.
Thank you.
Thank you very much, Mr. Maskery. Mr. Pendlebury? Mr. Havers.
Lady, I can't promise to be as concise as my own friend has been, but I'll do my best. All right. Yep. Thank you. That's all right. Move up a bit.
That's good.
Thank you. Thanks very much.
We need the microphones to transmit the proceedings.
Well, lady, I
You
had
realise
appreciated that. I thought that I was between two microphones where I was, but obviously they're the wrong ones. So my apologies. Lady, we respectfully submit that the first issue which arises on this appeal is whether this is a novel type of case. And we note that before he addressed that question, my own friend raised the question as to whether either the judge or the Court of Appeal themselves had considered this to be a novel case. He took you to paragraph 50, the Court of Appeal's judgment, but submitted that nowhere did the Court of Appeal indicate that they considered that this was a novel type of case. I'm not sure how far this issue is going to assist the court, but can I just show you paragraph 53 of Lord Justice Jackson's judgment, which is in the blue bundle at page 80, because it's clear from paragraph 53 that he did appreciate that this was a novel type of claim. He says, nor do I think that it is fair, just and reasonable to impose upon the receptionist or the defendant acting by the receptionist a duty not to provide inaccurate information about waiting times. This would add a new layer of responsibility to clerical staff and a new head of liability for NHS health trusts. So in our respectful submission, Lord Justice Jackson, with whose judgment Lord Justice Sales agreed, plainly did regard this as a novel type of case. In our submission, he was right to do so, because the question which arises on this appeal is whether NHS trusts, through their receptionists, owe a duty of care to members of the public who attend A&E departments in relation to information provided as to waiting times. There are no relevant precedent cases, by which I mean no cases where a trust has been found liable in negligence in respect of information provided by an A&E receptionist as to waiting times. And put another way, therefore, the case we submit doesn't fall within an established category of cases in which a duty of care has been found. In the healthcare...
Can I interrupt you?
I'm sorry.
The defendant is the trust.
Yes.
Is there any... Do you deny that the trust owes a duty of care to a patient in a hospital?
Nor the trust owes a duty of care to patients to provide those patients with adequate health care, and that is the nature of the established category of cases which have come before the courts so far. But none of those cases concern the question whether an NHS trust owes a duty of care through its receptionists to provide accurate information as to waiting times, and that's what this case it gives rise to.
Yes, the case against you is that at the moment that the person with an injury presents themselves to the receptionist
Yes.
to book in, the relationship, the therapeutic relationship of health trust and patient has come about. As I understand your case, you're treating the person merely as a prospective patient at this booking in process, and you're looking for some assumption of responsibility in the absence of the relationship. Is that right?
No, I don't.
That's not your position.
Well, that's not our position. I accept that once a member of the public has come into an A&E department and has been registered, as it were, has been accepted into the system, that person becomes a patient.
Yeah, so even if things are said in the process of registration, you're accepting as the starting point. They are a patient, but you're then saying that this is an extension of the health trust's liability to a patient.
I am, and I accept that the receptionist would have a duty to take care in the way in which she fills in the form, so as to ensure that the information that is then conveyed by the form to the triage nurse or the doctor.
Well, if she has a duty to fill in the form without negligence, why does she not have a duty to convey information to the patient which is reliable?
Well, I was going to come to that in the context of...
Come to it in your own time, Mr. Hale.
But the first... But let me try and summarise my answer to your Lordship now. That the first reason is that information is provided as a courtesy. It's not...
You say if you go into A&E and you say, how long is it going to take?
Yes.
Suppose you do that.
Yes.
Is it simply a courtesy to answer that question?
My lady...
So the receptionist should say, well, I don't have to answer that question, but out of kindness to you, I'm going to tell you, for example, accurately, you'll be seen by a triage nurse within 30 minutes, and the triage nurse will decide how quickly you'll be seen by a doctor.
Yeah, my lady,
That's simply a courtesy, isn't it?
We do say, as the judge said, and as the Court of Appeal, the majority of the Court of Appeal said, it is that information is provided as a courtesy. In other words, the other side of that coin is it's not provided pursuant to any legal duty of care, either to provide such information or to provide such information accurately.
But you would accept that hospitals do have, in certain circumstances, a duty to provide information to patients and to take reasonable care in providing that information. You do accept that, don't
Lady,
you?
I do, but that's almost always in a therapeutic or healthcare context.
Well, that happens to be the situation in reported cases.
Yeah, exactly.
But why is that situation different from this?
But because the information is being provided here not by a healthcare professional, a nurse, a doctor, or any of the other healthcare professionals that provide information in the hospital, provide advice and so on. It's being provided by the receptionists, who are they don't hold themselves out as having any special skills. They don't hold themselves out as being in any way clinically trained. They're simply clerical staff who are providing, registering, whose primary responsibility and function, as the courts below have said, is to receive the member of the public who attends an A&D department seeking treatment, and whose primary function is therefore to complete the form in a competent and careful way. And their function, I'm so sorry, their function doesn't extend beyond that in terms of a legal obligation, or any legal obligation, to providing information about waiting times.
But as the first point of contact with the public on arrival at an A&E unit, don't they have an obligation, don't they have a duty not to provide misleading information as to the availability of medical care?
Well, they would certainly have a duty, assuming that medical care was available, in other words, assuming that the hospital wasn't about to close down for some reason, because of, as they do sometimes, because they're simply overloaded.
As to the circumstances or the time frame within which medical assistance might be available?
Well, Lord, we would submit no. They don't have a legal duty to provide that information. But, and I've got various submissions.
My question the other way around, whether they have a duty not to provide incorrect information.
Yes. Well, Lord, we submit not, and that there are a number of reasons which I will come to as to why we submit it would be unreasonable and indeed unjust to impose such a liability on the trust via its or through its receptionist.
Would it make a difference if it wasn't a receptionist who manned the front desk but a nurse?
Lord? No, in our submission it wouldn't, because the key is the role or the function that the person in question is fulfilling. And if it was a nurse who was manning the reception desk, the role that he or she would be performing would be precisely the same as the receptionist herself would be, namely filling in the form and providing information as to waiting times if asked.
But what if somebody comes into a hospital and they're looking for a particular department and it's necessary that they get there as quickly as possible?
Yes.
And they ask the person on the reception desk, how do I find whatever it is? Let's assume they're going for some sort of test, which is very important that they have, and that they've got to be there by a particular time, otherwise they'll miss their slot, and the receptionist misdirects them, sends them to the wrong place.
Well, my lady, again, we would, I mean, I'm anxious to confine the case to the issue that it raises, although I entirely understand and expected your ladyship and my lords to raise alternative
just this sort
scenarios.
Of example. Yes, you
exactly.
did, didn't you? Yes.
And our response to your ladyship's question would be no legal liability arises from or should arise from an error made by the receptionist in that respect. I mean, if the patient finds that he or she gets lost because they've taken the wrong turning because of what the receptionist has said, then no doubt they'll ask someone else who will send them in the right direction. But to fix that with the consequences of legal liability, we submit would be both unjust and unreasonable. And again, it's not the function of the receptionist. The primary function of the receptionist is to receive the person who then becomes the patient. Can I just add this, that the arguments that I've made hitherto and the submissions that I'm going to make as to why it would be unreasonable to impose legal liability for inaccurate information provided by receptionists will apply no less to what logically is the next legal question that arises. That is to say, even if your ladyship and your lordships find that there was a duty owed, what is the scope of that duty? In other words, does the scope of any such duty extend to the provision of accurate information by receptionists? And at the end of the day, from the trust point of view, it matters not in reality whether your lordships analyse this case as a case which raises an initial question as to whether there was a duty of care at all, or as a case where what needs to be analysed is the scope of such duty. So, as it were, rephrasing the question that arises, does the scope of any duty of care owed by the Trust through its receptionists extend to providing accurate information about waiting times? And as I've said, the submissions I'm going to make, I make in relation to both those legal questions. But before I get to the question of why it would be unreasonable to impose such liability, can I just deal briefly with the analogy cases that my learned friend has relied upon? He only referred to one in his oral submissions this morning. That was the case of Kent against Griffiths. In his written case, he refers to an earlier case called Barnett, which is at page 109 of the bundle of authorities. Can I take you, and it will be brief because my known friend hasn't taken you to it at all. But your lordships will see from the headnote that the question that arose was in relation to what had been done or not done by the nurse on duty in the casualty department on the one hand and the medical casualty officer on the other hand. What was new or novel about the case was that there had been no previous case where the courts had had to analyse the position in relation to the actions of the casualty department. But as I say, in this case, the two individuals whose actions were under scrutiny were both medically qualified, that's to say the nurse and the duty medical casualty officer. And the judge found, if your lordships, my lady, would go over the page to 110, subparagraph 2, found that the medical casualty officer was negligent in not seeing and not examining the deceased, in not admitting him to the wards, and in not treating him or causing him to be treated. So this was an absolutely standard clinical negligence case in which a breach of the duty owed by the skilled doctor was found in conventional terms. The other case that he relies upon is at page 190 of the bundle of authorities, the case of Kent. The important point first to note about this case is that the context for the appeal was the judge's finding that the ambulance had not arrived within a reasonable time, specifically because there was an unreasonable and unexplained delay. One sees that from the first paragraph of the headnote, about 5 lines in, on the claimant's action for damages for personal injury from the ambulance service. The judge found that the ambulance had not arrived at the claimant's home within a reasonable time, that no satisfactory explanation had been given for the delay, and that if the ambulance had arrived within a reasonable time, there was a high probability that the respiratory arrest would have been averted. And if you would look on to page 196, paragraph 1 of the judgment of Lord Wolfe, with whose judgment the other two members of the court agreed. He identifies the issue thus: the issue on this appeal is whether an ambulance service can owe any duty of care to a member of the public on whose behalf a 999 telephone call is made if, due to carelessness, it fails to arrive within a reasonable time. So that was the issue on the appeal. Paragraphs relied upon by my learned friend in his written case begin at page 205 of the bundle, paragraph 45. And paragraph 45 begins, here what was being provided was a health service. Just to pause there, you will see, if you go back to paragraph 37 on page 203, that the judge had been summarising a line of authority relied upon by the ambulance service, which concerned the police, that's the Alexandru case, and the fire service, that's the Capital and Counties case. So when we go back to the opening part of paragraph 45, what the judge was doing was distinguishing the ambulance service from the police and the fire service, and expressing the view that what was being provided was a health service. And he goes on in the next line to say, why should the position of the ambulance staff be different from that of doctors or nurses? So one notes there that the comparison that the judge is making is between ambulance staff on the one hand and doctors or nurses, which of course is a comparison that can't be made in any way at all between receptionists and doctors and nurses. And then at in the next part of paragraph 45, I'm sorry, the report is one of those which has been downloaded from the internet. But if we begin just after the break in paragraph 45, the ambulance service is part of the health service. Its care function includes transporting patients to and from hospital when the use of an ambulance for this purpose is desirable. It's therefore appropriate to regard the London Ambulance Service as providing services of the category provided by hospitals and not as providing services equivalent to those rendered by the police or the fire service. So Lord Wolfe plainly, as I say, was using as his comparator doctors and nurses, and plainly took the view that the ambulance service have a care function. Again, not something that could be said about receptionists in the A&E departments of NHS hospitals. It's also to be noted, if you would look on to paragraph 48, that the appellant ambulance service did not suggest in that case that the danger to the claimant was not reasonably foreseeable, but they did not base their case on policy considerations. They accepted that imposing a duty of care would be fair, just and reasonable. They resisted it solely on the ground of proximity. And then at the end of paragraph 49, you will see that, or can I pick it up halfway through? As a result of that, Lord Wolfe says this: in other words, as there were no circumstances which made it unfair or unreasonable or unjust that liability should exist, there is no reason why there should not be liability if the arrival of the ambulance was delayed for no good reason. So there was no question in that case of it being suggested that considerations of reasonableness and justice should be addressed. The acceptance of the call in this case established the duty of care. On the findings of the judge, it was delay which caused the further injuries. If wrong information had not been given about the arrival of the ambulance, other means of transport could be used. And when seeking to distinguish the facts in Kent from the present case, we invite you to bear in mind 2 points in particular. As Lord Justice Sales pointed out in the Court of Appeal, I don't take you to it, but the reference is paragraph 86, page 87 of the Blue Bundle. The distinction between Kent and the present case is that when an ambulance service gives an inaccurate time for the arrival of the ambulance, this might lead someone to wait in the wrong place, for example at home, for medical assistance, whereas in the present case, and I'll come back to this in the context of patient responsibility later, in the present case, the patient is and knows that he's in the right place. He's already in the A&E department of a hospital. He's chosen to go there because he knows that that's where he will get treatment. And he knows that if he waits patiently in the A&E department, in due course treatment, he will be seen and he will get the necessary treatment. The other point of distinction is this, that in order to make a true analogy between Kent and the present case, one needs to adjust the facts of the present case along these lines. That is to say that the patient waited patiently in the A&E department, but then wasn't seen by the nursing and medical staff within a reasonable time. That would make the present case truly analogous with Kent. But of course, that's not the situation here. So, in other words, we respectfully submit that neither Barnett nor Kent assist the appellant in trying to find some analogous case to the present case, and that takes me therefore to the question as to what is the correct approach, or what should be the correct approach in determining whether a duty of care is owed if this is a novel type of case, and if there are no analogous cases to provide the first step in the approach that my Lord Reed set out in Robinson. That is to say, step one is to see, are there any analogous cases? Step two, if there aren't, then one goes on to consider whether it's just and reasonable to impose liability. Now, I'm conscious that that this is an approach which applies to those cases where what is said is that the case in question is a novel type of case. But in our submission, this should apply no less to a consideration of the scope of any such duty. In other words, the factors which would make it unjust and unreasonable to impose a legal liability in a novel case apply and should apply to the question whether the scope of any such duty should be extended so as to cover the circumstances of this case. And the circumstances of this case are, even if your lordships and my lady were to conclude that there is an overarching established duty of care owed by hospitals to their patients, those considerations would, we submit, apply to the question no less as to whether the scope of that duty extends to the giving of accurate information by receptionists as to waiting times. So can I then set out the various reasons why we submit that it would be both unjust and unreasonable to impose legal liability in these circumstances? And I have in mind my Lord Reed's statement in, I think it's paragraph 27, that involves looking at the reasons for and against doing so, and in the light of those reasons then deciding whether it is just and reasonable to impose legal liability. The first reason, let me begin by trying to put the issue into some sort of context. And can I begin with the numbers involved? Could I invite you first, please, to turn to our printed case, and to go to paragraph 27 at page 58 of the blue bundle, and at the same time to turn up a little clip of documents that we submitted relatively recently, which looks like this, headed Respondents' Documents, some 17 pages. I think it's 17 pages long. I do hope it's made its way to you. Yes.
I'm sure I've seen it. But you've also sent it electronically, haven't you?
We have. So
A separate electronic
It's
file.
a separate file. Yeah.
well then that can I invite you to go to it in that separate file. There are some hard copies coming around if any of you would like it. I think Lord Kerr would prefer to stick to the electronic file if my
And so would I.
recollection is correct. Yes.
Done with it, because I'm sure I've seen it. Yes. I'm absolutely sure I've seen it. So I must.
Well, maybe the electronic file
Yes.
will.
It's here.
It was there after all.
But it's also here.
Page 2 of 17.
Yes, that's it.
Page 2 of 17. Right.
So if I could ask you, I'm sorry to have, oh dear, if you're doing this electronically, that may not be so easy.
It isn't, is it?
No,
No.
I-
Well, it's not
Some people
impossible.
have got more than one screen. But
Well,
we're a bit
yes, or they can
old-fashioned.
divide up one screen into two, but shall we see how we get on? If I can take you to begin with page 58 of our case, paragraph 27. We set out what the position was when the case was before the Court of Appeal. The evidence was that there are about 450,000 visits to A&E across England every week, and about 3 to 8% of patients were reported to leave without being seen. Now, since then, something called NHS Digital has published final data on hospital A&E activity for the financial year ending March 2017. And that starts at page 7 of this further file, and page 7 of the hard copy, where you'll see NHS Digital, and then halfway down the page, Hospital Accident and Emergency Activity 2016 to 2017. And then the key facts are summarised at the top of page 9. And they include, there were 23.4 million attendances recorded at A&E in England during 2016 to 2017. If my calculator was working properly, that equates to 450,000 per week. This is in England alone. 89% of patient attendances spent 4 hours or less in A&E. Monday is the busiest day of the week, and in 2016, May and July have the highest number of attendances, but a higher proportion are admitted to hospital in the winter months. Now, just a little further way down that page under resources, you will see bullet point hospital accident and emergency activity 2016-17 tables, and one of the tables which if one clicks there, emerges, is table 25, which starts over the page of this bundle at page 10. Can I just indicate at the outset that this table is derived, that the original format of this table had 50, or it still has 50 columns, and wouldn't fit onto A4, and we didn't think it was going to be helpful to show you all 50 columns. So we've removed the columns which are not relevant, and we've also reordered the various trusts and the information by reference to the percentage of those who did not wait, in other words, who left before being seen. That's the right-hand column. So you will see that the figures have 3 columns to them by reference to a whole range of NHS trusts and similar units, hospitals and other NHS trust units. And the key figures for present purposes are, if you would go over please to page 12 towards the bottom, the second column, there were over 600,000 people who left without being seen, left without being seen, representing 3.1% of the total number who attended. For the respondent, that's to say this particular trust, if one goes forward a page to page 11, we can see that the relevant figures, this is about 6 lines up from the bottom of the page, Croydon Health Services NHS Trust, were 2,838 who left without being seen, representing 3.9%. And the range is between 0%, which is the, well, you can't get any lower than 0%, which is the, represents the, those at the very end of the clip at page 16, and 7.2% represented by the Rotherham NHS Foundation Trust at page 10. The only other statistic we would wish to draw to your attention is at page 2 of the bundle, which is addressed to A&E attendances and emergency admissions March 2018, and the 4th bullet point down tells us that emergency admissions in 2017-18 are up 3.7% on 2016-17, which is pretty much consistent with what one reads in the newspapers and is told generally about the increase in the workload of A&E departments up and down the country. So we submit that that provides important context for the question whether it would be just and reasonable to impose liability in these circumstances. We also submit that in the circumstances, Lord Justice Jackson was correct when he said at paragraph 53 of his judgment, page 80 of the Blue Bundle, that imposing liability for inaccurate information as to waiting times would add a new layer of responsibility to clerical staff and a new head of liability for NHS trusts. And I took you to that paragraph in his judgment at the outset of my submissions. So those are the numbers. Can I then turn to the environment in an A&E department? And can I, for this purpose, take you back to Lord Justice Jackson's judgment, paragraph 54 on the same page, page 80. This is the origin of the haven of tranquility phrase that Mr. Masker has already referred to. 54 at page 80. A&E department waiting areas are not always havens of tranquility. Tempers can become frayed as patients or their relatives are pressing for early treatment, and staff are seeking to ensure the orderly management of new arrivals and the prioritising of emergencies. The scene at Mayday Hospital on the night of 17th May 2010 may be a good example. So that's the environment that we submit forms an important part of the context for this issue. Thirdly, the receptionists won't be and couldn't possibly be expected to be making a note of what they say to every patient who asks them about waiting times. So they are extremely unlikely to have any recollection as to what they may have said to a particular patient, probably when asked many years later. because they would have spoken to a whole raft of different patients on one particular shift. Indeed, the trust is almost certainly going to have difficulty identifying precisely which receptionist spoke to which patient, as was the case in the present case, where the trust could do no more than to identify the receptionists who were on duty that particular evening.
I suppose it wouldn't be too difficult, would it, to either have a leaflet that was handed over to every patient when they booked in, or to have a notice up explaining. Would that be difficult?
Well, milady, it would be difficult because waiting times are never going to be the same. By definition, they're going to change depending on, as it were, the workload involved, the number of people waiting, and the time that it takes the triage nurse and others to triage patients. So, in our respectful submission, that would be actually more misleading than not having a leaflet at all. There'd then be the question, well, what if they run out of leaflets? I mean, there's a whole range of other subsidiary objections, but the one I've given is the primary one. And the result of what I've just indicated is that this is likely to make it very difficult for trusts to defend such claims, and your lordships and my lady may say, well, that's too bad. That's something that trusts will have to put up with. But it will also make it, we suggest, much more difficult for courts fairly to adjudicate on such claims. I mean, in the usual clinical negligence case, the nurse and the doctor, or the nurse or the doctor or the midwife, they will have made a note of what they found when they saw and assessed the patient, the treatment they recommended, and so on. Now, but that simply won't apply to receptionists, who, as I say, won't have time and can't be expected to make any such note.
If conventional principles of negligence can be applied to circumstances which have previously been unencountered, is the circumstance that they were previously unencountered, does that suffice to make it a novel claim?
Well, Lord, our primary submission is yes, it does. But our secondary submission is, well, even if it doesn't, the various factors that I'm addressing you on all go to whether it would be fair and reasonable to extend the scope of any such duty to the provision of information by receptionists in A&E departments.
So even if it's not a novel claim, you say that we have to address the fair.
Well, I do, and with respect that question, that legal question, hasn't arisen hitherto, because it wasn't the question that arose directly in the Robinson case. So that question remains in my submission to be decided, and we
the question being
whether whether it is right to consider questions of fairness and reasonableness when considering what the scope of the duty of care is, in addition to considering those factors when the question is whether there should be a duty of care at all. Robinson was concerned with the first of those questions, not the second. If you're against me on whether a duty of care arose in this case at all, that, as I've sought to submit, gives rise to the next question, which is, well, what was the scope of that duty? Specifically, should it be extended to cover the provision of information by receptionists in A&E departments? And our submission is that the considerations of justice and reasonableness that were deployed in the Robinson case should apply no less to your lordships and my ladies' consideration of whether the scope of the duty should be extended in this case.
But the premise of that submission is that an extension is required.
Yes.
I mean, the purport of my question is simply because a particular set of circumstances have not been encountered before doesn't make it a novel claim.
Lord.
And therefore there's no question of extending. It's simply the application of conventional principles of negligence.
Yes. To which I've sought to answer Your Lordship.
Well, I'm sure you've answered very
not very effectively so far.
That's my fault. I'm sorry.
Well, I'm sure it's mine. But by submitting that if Your Lordship is right and I'm wrong on whether this is a novel type of case, then...
Well, I haven't decided, Mr. David, don't worry.
But on that hypothesis...
susceptible to your advocacy.
On that hypothesis that Your Lordship puts to me, the court still has then to examine the scope of the duty. And there can be no doubt that there is no reported case in which the duty of care owed by a hospital or by an NHS trust to its patients has been held to extend to the provision of information by receptionists in A&E departments. And that being the case, we submit that it is sound in principle and logic that the court should, if Your Lordship is against me on this being a novel case, should then ask, well, is it reasonable to extend the scope of duty to cover the provision of information by receptionists?
Well, another way of putting your argument would be to pose the question, what is it reasonable to find as to the content of the duty? And you say that it's not reasonable to find that the duty extends.
Yes.
We can't really avoid that word.
No.
Extends to a receptionist giving information.
Nor I do so submit, and that is why I say that the factors that I'm addressing you on now are as relevant to the question as to the issue as to scope of duty as they are to whether there's a duty in the first place. I'm sorry, Lord.
Well, I'm just going to pursue Lord Kerr's point a little bit further, if I may. If one says that the duty of the NHS Trust, for example, is to take reasonable care to protect and promote the health of its patients.
Yes.
And if there are clerical tasks carried out by clerical staff employed by the Trust, which, if carried out carelessly, will adversely affect the health of patients, then one would have thought that was subsumed within the scope of the duty that I've suggested. So, for example, if the receptionist for a GP fails to post the letter referring a patient
Yes.
For an urgent assessment by an oncologist, for example, then that would fall within the scope of the duty of the. I suppose in that context, it might not be an NHS trust, but whatever the organisation is, clinical commissioning group or something. Or if a receptionist in some practices might be expected to label and send off samples for analysis, a blood sample, for example, taken by a nurse. And if she forgets to do it or mislabels it, then, these are all simply clerical functions, but they're vital to the performance of the Trust's work and can adversely affect the patient's well-being. And so one might say they fall within the scope of the duty of the Trust.
Yes. My Lord, those, of course, are examples of where the failure of the clerical staff would have could well have a direct effect on the health of the patient. So, the failure to send off a sample of some sort to the laboratory to be tested is a good example of that. That's where we say an important distinction has to be drawn between those cases and the present case, because the present case is altogether different. And I'm going to come back to this in the context of patient responsibility when I get to it shortly, because this case, in this case, as I've already submitted, the appellant was in the right place. He knew he was in the right place. He'd deliberately come to the A&E department for that reason. He knew that if he waited, he would be seen. Two crucial findings that the judge made were that he was told that he'd be seen if he waited in up to, not in 5 hours, but in up to 4 to 5 hours. And that if he collapsed in the meantime, then he would be seen as an emergency. So whatever the receptionist should have said to him about being seen by a triage nurse within half an hour, what he was told and what therefore he knew was that not only was he in the right place to be seen and to be treated, but that if he waited up to 45 hours, he would be seen and he would be treated. So the provision by the receptionist of inaccurate information didn't wasn't never going to affect his health, because he knew all that, and yet he chose not to wait to be seen in the A&E department, but instead to leave.
Well, of course, there is also finding, in fact, that it's reasonably foreseeable that a person who believes it may be 4 or 5 hours before he'll be seen by a doctor may decide to leave.
And all that is true. But that we would say, in every case where that occurs, that's a free voluntary decision being taken by the patient, who knows that if he waits patiently, he will be seen, but nonetheless freely and voluntarily decides not to wait. So in all those cases, those patients, they're in the right place, they will receive treatment if they wait, but they voluntarily choose not to do so.
But really, it doesn't matter if misleading information is given by the receptionist, because at the end of the day, it's always the voluntary decision of the patient to walk out. That's really what it boils down to.
Correct. Yes, yes, that is right.
I can-
as long as I'm so sorry, my Lord. As long as there's some reason to believe that they will be seen, and in this case, there was every reason to believe that they would be seen, because the appellant was specifically told that he would be. I'm sorry, my Lord.
No, not at all. No, it's just I can see one could emphasise the voluntary act of the patient if the patient was merely a prospective patient. But once you accept that a therapeutic relationship exists between the trust and the patient or prospective patient at the point of booking in, then given we're talking about a head injury, I wonder if the independent decision of the prospective patient or patient at that stage is sufficient to negative the duty of care which you accept in other circumstances.
Well, Lord, this was the point that Mr. Maskery made in his submissions this morning. I didn't do the trial, but I'm told that it was never suggested that the appellant's decision to leave was other than a voluntary decision. So I don't understand it ever to have been suggested that in some way that decision was impaired because of his condition.
The evidence was that it was taken on the basis of the information which had been provided to him, that it would be up to 4 or 5 hours before he would be treated.
Yes.
And there was also evidence from his friend to the effect that he would have, that if he'd known he would be seen within a shorter time, he would have seen to it that he stayed.
No, that was the evidence, but our submission is that one has to look at the evidence in its totality, and whatever he should have been told about being seen by a triage nurse within half an hour, he hadn't been told that, but he had been told that if he waited, he would be seen within up to 4 to 5 hours, maybe sooner. It must follow from up to that it might have been sooner. So even on the basis of the information with which he was provided, he knew that if he was patient and waited, he would be seen, and yet he took the voluntary decision not to wait. I mean, I'm going to come to that in the context of whether, and this is looking at breach of duty in a slightly different way, whether in those circumstances the legal responsibility for that decision should rest with the trust at all, or whether, if, as the judge found, this was the decision of the claimant himself, the appellant himself, and it was a voluntary decision, legal responsibility should not lie entirely with the trust, but with the appellant. But I'll come to that in a moment when I have something to say about patient responsibility. Can I therefore go back to the reasons why we say liability should not be imposed, either because a duty of care should not be imposed or because the scope of that duty should not be extended to cover information provided by A&E receptionists. And to some extent I've touched on this already. The next point, the next reason we say why liability shouldn't be imposed is that the receptionists aren't performing a healthcare role, they're not exercising some special skill, nor indeed do they suggest that they're qualified to do so. That was not the position in Wiltshire, which known friend showed you briefly this morning, where it was the question was all about whether the personal attributes of the particular doctor who was treating the patient should be taken into account or not, and the answer was no, it's the post, the role, the function that the individual is performing that is the key. But it was in that case it was a junior doctor whose conduct was under consideration, and that is to be contrasted with the position of the clerical staff, the receptionists in the present case. And we would go further and submit, as Lord Justice Jackson found, I'd probably suffices if I simply give you the reference, paragraph 51 at page 80 of the Blue Bundle. It is not their function, or indeed their duty, we submit, to give advice or information as to waiting times. If they do so as a matter of courtesy. But that's where it stops. Next, we submit that, and again I've touched on this in answering questions, we submit that to impose liability in these circumstances would in practice be unworkable. As I've already suggested, the information as to waiting times will change during the course of time for all sorts of reasons. For example, the arrival of some patients who are in greater need of being seen than the patients who have turned up already. So the information that's been provided by the receptionists to that point to patients will now no longer be accurate. What are the receptionists then supposed to do? Are they supposed to look around the waiting room and remind themselves which of those patients they gave that now inaccurate information to? And if so, are they then to leave the reception desk to go and find them and to tell them that the information in question is no longer accurate and the waiting time they gave them earlier needs to be the waiting time needs to be changed? Are they required themselves to regularly update themselves as to waiting times? Because, as I've said, the times may change. Should they leave their desk and go to and seek out the triage nurse or one of the doctors to find out what the now current waiting time is? And if the doctor's busy or the nurse is busy, are they supposed to wait until they're free, or should they go back to their reception desk so that they can process the next patient to arrive? All this, we submit, would put receptionists in a near impossible position and would in practice be unworkable. Indeed, it is virtually inevitable that sometimes information provided by receptionists as to waiting times will turn out to be incorrect. And yet what is sought is to impose legal liability in respect of that information. So, Lords, although I would usually hesitate to advance a floodgates argument, and although Lord Justice Jackson said in terms in the Court of Appeal that he was not usually sympathetic to floodgates arguments, litigation about who said what to whom in A&E waiting rooms could become, as he put it, a fertile area for claimants and their representatives, not least given the numbers involved that I showed you a short time ago. And this is the next reason I rely on, that the outcome might be, as was acknowledged by both the judge and the Court of Appeal, that NHS trusts simply close down this area of risk altogether and tell reception staff not to say anything about waiting times to patients, because the information may be already or may turn out to be incorrect, and that's simply going to give rise to difficulties. And that, as the judge observed, would obviously be unhelpful to patients. So, as I've submitted already, the provision of such information by receptionists as to waiting times is a courtesy on a proper analysis. And if that is correct, then that is not consistent with imposing legal liability for such information. The final point is this. I've already made the submission that those who attend A&E departments are in the right place and know that they're in the right place and know that, provided that they're patient and that they wait, they will be seen and treated as appropriate. And what's more, they know that if they collapse in the meantime, they will be seen as an emergency. So that being the case, we submit that there is no good reason to impose such a liability. In other words, it isn't necessary to do so. So, my Lords and my Ladies, those are the reasons we rely upon in submitting that whether you analyse the case as a novel type of case or whether you analyse it as a scope of duty case, either way, legal responsibility for providing accurate information in these circumstances should not be imposed. That takes me to patient responsibility, about which I wanted to say something. We also submit that not to impose liability in this case would be very much in keeping with what we have described in our printed case as the modern way of, the modern view of patient responsibility. That is to say, patients take responsibility for risks affecting their lives and for the consequences of their choices. And a powerful example of that modern view is what my Lord Kerr said in Montgomery. It's at page 374 of the authorities bundle, paragraph 81, and I would like to take you to the paragraph, if I may.
It's, myself and Lord Reid, of course, gave a joint judgment in that.
Yes, Lord, your Lordship is absolutely right. Page 374 of the authorities bundle. Paragraph 81, the social and legal developments which we have mentioned point away from a model of the relationship between the doctor and the patient based on medical paternalism. They also point away from a model based on a view of the patient as being entirely dependent on information provided by the doctor. What they point towards is an approach to the law which, instead of treating patients as placing themselves in the hands of their doctors and then being prone to sue their doctors in the event of a disappointing outcome, treats them so far as possible as adults who are capable of understanding that medical treatment is uncertain of success and may involve risks, accepting responsibility for the taking of risks affecting their own lives and living with the consequences of their choices. As I've emphasised too often already, a member of the public who attends an A&E department knows that he will receive medical treatment if he is patient and if he waits. If he chooses not to wait, we submit, he must take responsibility for the risks and the consequences of his decision not to do so. As your lordships all know, and my lady knows, in the present case, the judge found that the appellant was told that he would be seen in up to 45 hours, but he decided not to wait to be seen. And the judge put it this way at the very end of his judgment. Can I take you back to the blue bundle and to page 106? And pick it up towards the end of paragraph 92. He knew, 4 lines up from the end of the paragraph, he knew that ultimately he would be seen. He took the decision to leave before he had been seen. Ultimately, it is the claimant who must take responsibility for the consequences of that decision, not the defendant by its reception staff. So if a member of the public decides not to wait to be seen, we submit legal liability for the consequences of that decision should not rest with the trust. To put it another way, it is not the duty of NHS trusts to save patients harmless against the consequences of their voluntary decisions not to wait to be seen and treated. Lady of the Lord, I think that's all I wanted to say about novelty of case and scope of case and patient responsibility. Can I just, if your lordship, my lady, would just give me a moment to... Yes, so can I move on to breach of duty? I can take this very shortly. Mr. Maskery says, well, breach is obviously made out in this case because the judge found that the receptionist failed to tell the appellant what they should have told him, namely that he would be seen within half an hour by a triage nurse. But if you're against us on the issues I've addressed you on so far, then breach of duty does arise. But we say that it's essential to consider what the appellant was told in the totality. And we know that he was told that he would be seen effectively if he waited for up to 4 to 5 hours. So the receptionist said nothing to make him think that he wouldn't be seen and that he wouldn't then receive treatment if he waited. So looked at as a whole, he was told that if he waited, he'd be seen, and that we submit is sufficient to satisfy the duty of care, assuming that your lordships have found that a duty of care of this scope existed. Nor as that takes me to causation, which I can deal with very simply. We submit that the appellant suffered his damage because he chose not to wait to be seen and treated, having been told that if he waited, he would be seen, and that if he collapsed whilst he was waiting, he would be treated as an emergency. So on that simple basis, we submit that causation must fail if my lady and my lordships have got to that stage in the analysis. My Lord Reid mentioned contributory negligence as a possible control mechanism. Our short submission is that that simply doesn't arise in the present case.
No. I wasn't suggesting...
No, and I'm grateful to your lordship for clarifying that. I say no more about it. And indeed, other than this, it's not going to arise in any similar case where a patient chooses to leave without waiting to be seen and treated. Yes, I'm reminded that the timing provided in the present case of up to 4 to 5 hours it more or less reflects the operational standard for A&E waiting times. If I could ask you to go back to that little clip of documents that you will have either in hard copy or as a separate file, and to go to page 3. And this is part of the first document, you will see under background, 3 lines down in the first paragraph, the operational standard for A&E waiting times is that 95% of patients should be admitted, transferred or discharged within 4 hours of their arrival at an A&E department. So the 4 to 5 hours reflected more or less the operational standard that currently obtains. Unless I can assist your lordships and my lady any further, those are our submissions.
It appears not, Mr. Havers. Thank you very much indeed. Mr. Martin? Mr. Maskery.
My lady, my lords, I think I can be relatively brief in reply. First of all, is this a novel type of case? Mr. Havers' submissions really amount to saying, well, you must be able to identify a previously litigated case and provide its name, and then you can say that this is not a novel type of case. Any other situation is indeed novel, but that, of course, is contrary to what was said in Robinson, and I need take you only to pages 411 and 412 of the bundle. I've been there before. 411, paragraph 25. Lord Bridge gave guidance as to how novel questions should be decided. I think the law has now moved in the direction of attaching greater significance to the more traditional categorization of distinct and recognizable situations, not different cases that have been litigated, distinct and recognizable situations, thus making the point that my Lord Reid made, that one can imagine distinct and recognizable situations to which the established principles apply, and this is one of them. And likewise at paragraph 27, when it is said it is only normally in a novel type of case, and then the words that I emphasized when I opened, where established principles do not provide an answer. Thus, it's not simply the novelty, it's where established principles do not provide an answer. Established principles, we submit, do provide an answer here. So my learned friend is forced, if he can't say this is a novel type of case to which established principles apply, to say that the concept of fair, just and reasonableness comes in via the back door when dealing with scope of duty. But my lord, my lady, when defining scope of duty in the context of this case, we submit that Mr. Havers made the error that the Court of Appeal made. He defined scope by reference to the receptionist, not by reference to the trust. And when determining scope of duty, one determines it not by reference to distinct and different categories of employee, but to the trust. So one asks, what was the scope of duty in this case owed by the trust? It was to take reasonable steps to protect the claimant from personal injury that was foreseeable. And to attempt to say that when analysing the scope of duty, one looks at different categories of employee, it is to run counter to the concept of duty of care and the scope of that duty being owed by the defendant. Of course, he's right that the category of employee comes into play at the question of breach, because one does not analyse whether a receptionist has been in breach of duty by reference to the standards of a doctor. And so, of course, the categorisation becomes important, but at that stage. And here, we accept, and we accept it expressly, that when determining breach, one looks at, first, was it reasonable for the defendant to have placed a receptionist in that position? Answer, yes. Second, did that receptionist carry out her clerical duties appropriately? Answer, no, because in answer to the question that she was asked, the usual answer, the answer the expert said should be given, and the actual protocol at the time was to say, you will be seen within 30 minutes. To differentiate, to distinguish that by saying, well, up to 4 to 5 hours incorporates 30 minutes, is, with great respect, one removed from the real world. No ordinary person would take those two concepts to mean the same thing. And it was thus misleading. So whether one looks at the case from a point of view of duty or scope of duty, we submit that one does not need to get into the question of issues of fair, just and reasonableness. But even if this is a novel case, what is the incremental approach? One looks at analogies. Mr. Havers criticised the fact that we had relied upon Kent because he said, well, Kent is a different factual situation. Well, of course it is, because we're talking about an incremental approach. But what we say in relation to Kent is that if one looks at the case itself, page 206, paragraph 49, here, Lord Wolfe says at the end of that paragraph, on the findings of the judge, it was delay which caused the further injuries. If wrong information had not been given about the arrival of the ambulance, other means of transport could have been used. Now, there were two aspects of the allegation. One was the ambulance was negligently late, but this is why I said there were two ways of looking at the case. But the other way of looking at it was that incorrect information had been given. And what is analogous to this case is that the ambulance control was not performing a medical function at that point, but a simple clerical function, passing on information. That is analogous to this case. And
in other words, you say that transposing Lord Wolfe's words, if wrong information about the timing that he would be seen had not been given, it's more likely that he would have stayed.
yes. And Kent was considered by this court in Michael. And my lords, my lady, may I take you to page 326? And the only reason I take you there is to make the point that there are two ways of looking at Kent. One, the ambulance was negligently delayed, but two, there were misleading assurances. And in Michael, that point was made by this court. At the bottom of the page, letter H, the case is very different from Kent and Griffiths, where the call handler gave misleading assurances that an ambulance would be arriving shortly.
Sorry, that's paragraph.
It's H at 326 at the bottom of the page.
138,
138.
bottom of 138.
Thank you very much.
Oh, I'm sorry. Yes, 138. I'm so sorry.
Yes, got it. Thank you very much.
So for all those reasons, we say not novel, incremental approach. Incremental approach leads to the conclusion that there is a duty of care here that was breached. If I'm wrong, and we have to consider fair, just and reasonable, then I only have these submissions to make. I don't want to sound flippant, and I'm not being flippant, but it may appear that way initially. My lady, my lords, if Mr. Jeremy Hunt were to inject 10 billion into the NHS tomorrow, would that change whether there should be a duty of care? The respondents seem to be suggesting that it would. If that is right, then what the respondents are actually contending for is a sliding scale, an ever-changing duty of care. And that cannot be right. A duty of care exists or it doesn't. And when one considers the particular circumstances of the case, one takes into it, and whether there has been a breach, that's when one takes into account all the various factors that are mentioned in the statistics. Moreover, where do the statistics take us? It cannot be the case that simply because, as a generalisation within the NHS, a large number of people leave A&E, that one ignores what is actually happening on the ground at a particular trust or in a particular hospital. So the statistics don't take us anywhere at all. Mr. Havers says, well, leave the statistics to one side. This is going to be tremendously difficult for trusts to defend. For all of the evidential points that he makes, he ignores perhaps two features. First, the burden of proof is on the claimant. And if the claimant cannot prove, so the judge considers that what he says or she says is reasonably probable, then he loses, she loses. And judges are well used to situations in which there is a conflict of evidence and they have to deal with it, and well used to the situation in which a witness comes along and says, well, I don't remember what happened on the day, but this is my practice. This is what I would have said. Mr. Havers also ignores when he says, but in the world of the clinical situation, the doctors and nurses are all making notes. He fails to advert to the fact that claimants rarely are making notes at that time. Doesn't alter the fact that the burden of proof is on the claimant to establish the facts. The complaint that there are evidential difficulties simply won't do. He does not mention at all the other side of the coin, which I mentioned in opening, repeat again. One also has to look at it, in the words at the back of the court, one has to look at it not simply on the basis of, well, is it fair to the NHS, but is it also fair to a claimant in these circumstances when he is in the defendant's environment and is vulnerable? I can't say that he did not have capacity. For obvious reasons, I can't say. But I can say that he was a man with a head injury and a man who 2 or 3 hours later had collapsed and who was saying at the time that he was in extremis, plainly vulnerable. I come to with that in mind, the assertions that have been made about patient responsibility. With great respect to Mr. Havers, it ignores what we submitted early on. And that is, what we have to prove is that the defendant's information played an active part in the decisions that the claimant took. Again, I go to Robinson at page 424. And it is where my Lord Reid at paragraph 72 made just that point. The claimant does not succeed if, and I am 6 lines down at para 72, in cases where the defendant played no active part in the critical events. Now, the one thing that is not only clear, but was found as a fact by the judge, is that the defendant's information played an active part in the critical event, namely the decision on the part of the claimant to leave. And if it did, and if it can be proved by the claimant that he would not have left but for that information, then we have established factual causation. If we can't prove that, then we fail on factual causation. And situations, as we've been here before, as my Lord Reid indicated, situations can exist where there is a sharing of responsibility. But they depend upon the circumstances of the case. And it is not a black and white situation. If a claimant chooses to leave, irrespective of what he's told, irrespective of what the defendant may or may not have done, it's his choice. It's manifestly not true, because it is not simply his choice. It is his choice in the context of what he is told. And that, of course, is Montgomery. Nobody is suggesting that in Montgomery, if a patient makes a voluntary decision not to accept treatment, for example, that claimant fails in circumstances where the clinician has given misleading information. Nobody would suggest that in those circumstances, well, it was the claimant's voluntary decision not to accept treatment, therefore there's no cause of action. And that is this case, albeit that this is a clerical mistake that was made rather than a clinical mistake that was made. I say nothing more about breach of causation. My lady, my lords, would you forgive me if I address one point made by my Lord Hodge? My lord indicated or asked whether it was the defendant's case that the claimant was a prospective patient rather than actually a patient. Given the concessions that have been made, that is plainly not this case.
No.
But it is of importance, and may I address it, though it is not this case. Our submission is that the duty of care exists because what matters is that there is a relationship. Once there is a relationship between the claimant and the trust, there is a duty of care. Thus I made the point that as one walks in through the door, there's a relationship. There is a duty owed by the trust as an occupier. So as soon as one walks through the door...
Yeah, but that's a different duty relating to different things.
Absolutely, absolutely. So the question arises that at what point is there a relationship at which the trust is taking some responsibility for the health
That's why I asked about a therapeutic relationship.
Absolutely right. And the point at which that exists, we submit, is the point at which it can be told by, is the point at which the defendant knows that a claimant is seeking help and assistance and medical care. It doesn't depend on whether notes have been written. It doesn't depend upon a booking situation. Thus, for example, if somebody walks through the door and collapses, it does not matter that they haven't been booked in. What matters is whether the defendant appreciates that the claimant is seeking medical attention. And it's at that point, whether you call them a patient or a prospective patient, doesn't matter. Yeah. It's at that point.
Yeah, I mean, if once there is a therapeutic relationship, then you say you don't have to look for a separate assumption of responsibility for the accuracy of statements made if they foreseeably will affect the patient's health.
Thank you, my lord. I'll sit down.
Before you,
Yes,
could I just ask, if the court were to be with you, do damages still require to be assessed?
Yes. My lady, my lords, I have no further submissions.
Thank you very much indeed, Mr. Maskery. Thank you both. The economy with which you expressed yourselves in writing has been mirrored by the economy with which you have expressed yourselves orally. We're very grateful to you, not only for that, but also, of course, for bringing this interesting case before us. Is there something you'd like to say?
No, my lady, I'm simply standing up.
Well, standing up in anticipation of my standing up.
I was always taught to stand up when being addressed by a judge. And
Well, all I say is thank you to everybody, and not only to those who are on their feet, but also to those who've been living with this case for rather longer than the two from whom we have heard. And we will now go away and work out what we think the answer is. Court is now adjourned.